Trust the only payment solution offered through the ABA Advantage program. LawPay.
The practice of law changed significantly in the past decade, and perhaps the biggest disruption arrived in March 2020, when the coronavirus pandemic forced most lawyers to leave their offices and work remotely. There's been challenges and fears for the profession, as well as the necessity to quickly change the way some things have always been done. That's hard for lawyers. And as part of a special series, the ABA Journal's Asked and Answered is asking lawyers about how they've done it and what they think will come next. I'm Stephanie Francis Ward, and my guest today is Howard Bashman, an appellate lawyer who also writes at How Appealing, a popular blog that has been in existence since 2002. Howard, welcome to the show.
Pleasure to be here. Thank you.
I love it. You've been writing since 2002, and your blog is every bit as useful now as it was when you started, and just as popular. How did you get the idea to do it? What prompted you to do it?
Well, thank you so much. I had been writing an appellate column for the legal newspaper in Philadelphia, Pennsylvania, which is where the region in which I practice law, since December of 2000. So I've been writing that for over 20 years now. And there had been times when issues would come to my attention that perhaps would not merit a full month's treatment in that monthly column that I thought people might be interested in hearing about. And around that same time, someone brought to my attention the existence of law blogs in general, and in particular, the Volokh conspiracy written by a law professor at UCLA.
Mm-hmm.
And
Eugene Volokh, yes.
Correct. And so I was hesitant to even want to take a look at that because I figured, who cares what law professors are opining about? But eventually, after numerous requests to look at it from a colleague of mine at my law firm, I did take a look at it, and it actually was very interesting. And that blog continues in existence today and remains very interesting. So I thought maybe this platform would give me a way to discuss appellate issues with others that are interested in it, other than that monthly column that I was writing. And so I did a quick search to see if there were any other appellate blogs in existence at the time and did not find any. And I decided to give it a shot. And to my amazement, it did catch on and continues to be in existence today. I think in an interview on C-SPAN, Justice Kagan says that it's one of the blogs that she reads regularly. I was invited to speak at a Fourth Circuit conference that was taking place in the Fourth Circuit, and their regular annual speaker is the Chief Justice of the United States, who was already John Roberts at that time. And I bumped into him at a reception, and he said, "Howard, if you're here, who's writing your blog?" And it was just shocking to me that people at these levels are looking at it. So I try to put that out of mind when I write on it.
Well, I think that is a very good question, because you post, you'll put up 8 posts a day and on the weekends. Do you do it by yourself or do you get help?
The entries are all my responsibility, so that is all done by me. But in terms of help, I do have a loyal group of readers who will email me, and now with the advent of Twitter for many years, they can contact me that way. And also I follow a number of folks on there that are in the news industry covering legal developments, and so that's how I keep track, in addition to trying to visit the websites of each of the regional federal appellate courts each day or every other day to see if there are any interesting new decisions.
Okay. Let's switch gears for a minute and talk about your appellate practice. I am curious, during the past year, during the pandemic, have things been that different for you as an appellate lawyer? Because I think for a long time, appellate lawyers already were working from home. I'm not sure if you were, but it's kind of in some ways it's kind of a solitary pursuit, at least in the writing process.
No, that's true. So just to take a step back to the larger picture, I became a solo appellate practitioner in February of 2004. And my office, I do have an office that's outside of the home, and it's located 5 minutes away in the neighboring town. And so I had not been predominantly working from home, except when necessary, of course. Sometimes the legal profession, unfortunately, does require one to work nights and weekends. And so from time to time, it might be more convenient for me to continue working on a project from home instead of heading back to the office. But principally, up until everything shut down just about a year ago from now, I had been working in the office predominantly 5 days a week minimum. And so when things did shut down, that did result in a major change for me, which meant instead of working in my office with the things that I had around that I would need, such as the postage meter and my fancy printer and all of my supplies, I started working from home, which is where my wife had already been working in her job as a writer. And the weekends, almost exactly a year ago, we had to pick up our son, who was a third-year law student at NYU School of Law, which had just shut down for what they thought might be a short period. Of course, he ended up finishing his third year and graduating from home. And so that was something of a large change. But as you had said, the practice of appellate law tends to involve reading and writing and researching, and those are things that don't principally require you to be anywhere other than at your office or near a computer with an internet connection. And so in large measure, those things had stayed the same. Now, in Pennsylvania, which is where I practice, and I handle appeals in both the federal appellate court, which is the Third Circuit, and the state appellate courts of Pennsylvania. The state appellate courts immediately began entering blanket extensions of all due dates that lasted from that point in March, when everything started to shut down, through essentially the middle of May. And so there was a 2-month period right there where nothing was due. And it was unclear if that meant that trial courts didn't have to do their own work in terms of the judges there in issuing opinions in matters that were submitted for decision. So there was a great deal of uncertainty originally. And I wrote a column, I think it appeared probably in April or May of last year, in which I wanted to make the point, and did make the point, that the coronavirus pandemic should not grind all appellate proceedings to a halt. Because unlike cases going to trial where perhaps you have to be there in person, and I know that we've seen some efforts at doing those remotely recently, but traditionally you have to be there in person. For the appellate work, you can do that from wherever you're located, as I had demonstrated to myself for the initial 14 years of my solo practice, in my office working on appeals while my co-counsel or trial counsel or referring counsel or the client were in other locations.
I get the sense that for a lot of litigators, this has been tough because you said there is some uncertainty and business is just really, it's slowing down. Do you get the sense it's that way for the appellate practice too? Because as you said, you can do it remotely and it's writing, but I mean, nevertheless, I feel like the trial work itself is getting pushed back because most people don't want to do telephone deps, for instance. And then, it's people may not be, you can just keep churning. So do you notice a difference in the appellate practice with business?
To prepare for today's podcast recording, I did take a look back at the prior year of my work life to see what I was up to. And of course, to get my taxes together, I had to look and see how last year was financially. And so I can answer your question in a couple of different ways. The good news is that things eventually did pick right back up in the appellate practice that I have, so that over the past year, I ended up arguing 5 appeals remotely over this same video setup that we're looking at each other on now as we record the audio of this podcast. And the Pennsylvania State Appellate Courts did begin holding oral arguments remotely using either video or telephone. And although the criteria to have a case be argued became a little bit more stringent, it appears that in effect, if you took the trouble to ask for it, they would give it to you. So that in the cases that I was handling where we wanted to have oral argument, or if I was on the winning side where the other side wanted oral argument, in all of those cases, oral argument was did end up occurring by request of one party or the other. And those tended to go very smoothly. In fact, when everything shut down, I had just argued a case about a week before that on March the 3rd of 2020. And I had two more oral arguments scheduled for that month in front of the same Pennsylvania Intermediate Appellate Court. One was an en banc argument scheduled in front of 9 judges. I think the date was going to be March 18th, but if that's not exactly correct, it was for the middle of March. And then I had a second oral argument coming up at the very end of that month before a 3-judge panel. It turned out that my mid-March en banc oral argument was rescheduled for June the 3rd. And so that was essentially just a delay of 3 months. And that decision ended up coming out several weeks ago now. So that was just decided. It was very different to argue in front of 9 judges over the computer. And of course, as compared to an in-person oral argument, this court decided to do it the same way that the U.S. Supreme Court has been doing it. Even though there was a video hookup so we could see the judges took turns one after the other asking their questions. And yet it went off totally without a hitch. And then, as luck would have it, on that day, June the 3rd of 2020, at about 12:15 in the afternoon, one of these horrible summer storms came through with a Derico, which is these sideways winds about 50 miles an hour, and totally knocked out power in my entire region. And so if my oral argument had not been the first case that day, I probably wouldn't have been able to give it because we didn't even get power back for 32 hours after that. So there's definitely some luck involved in arguing remotely, even though it is in many ways way more convenient. So to get back to your overall question, things did eventually pick up, and in a combination between that fact and the fact that early last year I was fortunate to receive a success payment in a matter that I'd worked on early in the year. It ended up for me not being a bad year overall, but like you said, the types of cases that are being heard on appeal now tend to be the ones that involve decisions by judges on legal issues as opposed to end of case decisions following a trial, because those sorts of matters are not going to trial right now. So presumably once we get back to that, it'll be busy again, maybe later this year or early next year.
Well, I'm curious, in terms of the cost of a pretrial motion appeal or a verdict appeal, is the cost about the same, or is the motion or the appeal of a finding, does that usually cost less than if you're appealing a verdict?
I think that you're right that post-trial appeals can be more work-intensive and therefore end up costing more in general. But there can be matters that involve complicated legal issues that are decided at the pretrial stage that can themselves sometimes be very complicated, and so it's difficult to say that one category of appeals necessarily will result in a higher fee than another, because as you can imagine, you might have a day or two trial of a case. You could have a month-long trial, and obviously, those two types of post-trial appeals, you would think would require very different amounts of work to handle.
I think I've heard before that some appellate lawyers and judges will say it's not really about the oral arguments. It's really in the writing. There's not a lot that's decided in oral arguments. Do you have thoughts on that, especially now? Because, what I'm hearing from appellate lawyers is that oral arguments are maybe not as enjoyable because there's just not as much back and forth between the court. But I'm wondering what you have a take on that? Is maybe their minds are already made up from the writing before the hearing?
As an appellate advocate, my view is that it is very useful to hear from the judges if they have any concerns about either my position or the other side's position that can be explored during oral arguments. The Pennsylvania Intermediate Appellate Courts tend to be very permissive in allowing oral argument. I've already described a little bit of that as to how it worked during the pandemic. But before the pandemic, all that you had to do was ask for it. And so that in a way hasn't changed, even though you have to ask for it several more times during the pandemic. But before the pandemic, you only had to ask for it once. Now you have to ask for it several times in a row to get it. But the Pennsylvania State Appellate Courts had always been very indulgent in allowing appellate oral argument. And I think that that's a good thing. By contrast, the Third Circuit, which is the federal appellate court having jurisdiction over Pennsylvania, is among the federal appellate courts that hears oral argument the least of all federal appellate courts across the nation. I'm not saying it's the very least, but it's close. It's in that group that's at the bottom. And I think that during the pandemic, the Third Circuit has cut back to a degree on the number of cases that it's hearing oral argument in, so that percentage has gotten even smaller. So if you want to ask me, do I think that that after the pandemic, for example, we should keep doing this through the computer from my home office as compared to doing it in person, which I think is a question that many people will be asking themselves who are in this area of practice. I can save hours making the 5-step walk from my closet, putting a suit on to this computer, as compared to getting in my car, either driving to a train station or driving directly into Philadelphia. And so there certainly are huge savings in terms of the time and effort involved to get in front of the judges in having these things occur remotely. And the judges, many of the judges are experiencing the same time savings as well, because these oral arguments tend to occur in centralized locations, whereas the judges can have their offices throughout the state near their homes. But I think that something is lost as a result of not being there in person. And so I hope that the thing that remains after the pandemic is the increased ease of access to the oral arguments live themselves, either over the internet or through other means, but that to the extent possible, we can actually get back into the courtroom and have these presentations occur in the way that they had in the past, which was largely in person.
Okay, let's take a quick break. And when we come back, I'm going to ask you some more about your blog. We'll be right back.
LawPay makes it easy to securely accept credit, debit, and e-check payments from anywhere. Because LawPay was developed specifically for the legal industry, your earned and unearned fees are properly separated and your IOLTA account is protected against third-party debiting. To learn more about the only online payment solution offered through the ABA Advantage program, visit lawpay.com/ABA.
And we're back. I'm Stephanie Francis Warren, and on today's episode of the ABA Journal's Asked and Answered, I'm speaking with Howard Bashman, an appellate lawyer who is also the person behind the popular law blog, How Appealing. So tell me about your tips and how you find things. And I'm curious if you have Twitter lists. How do you dig?
I do have a Twitter list that is very helpful. And
is it private or do you have it public?
Excellent question. So this is a Twitter list that somehow I found one day when somebody added me to their Twitter list, and
okay.
And this is an appellate attorney who practices, I believe, in the DC area, and so he had already followed many of the sources that I find very useful to access on a regular basis, and then out of the blue one day, I go to refresh the entries on that Twitter list, and I get the notice that the account has gone private. And so fortunately, I had retained the main Twitter information for this user, and so I contacted the person and I said, do you mind if I could follow you, because I find your Twitter list to be very helpful. And once somebody takes a list private, if you're one of their followers, you can still access it. And so this particular Twitter list is not publicly available anymore, but fortunately is still available to me. But to answer your question, beyond Twitter has greatly changed many things with regard to being an appellate law blogger. There once was a time where, if I understand what people were saying to me, they would rely on my blog to inform them of new newsworthy decisions. These days, as a result of the fact that so many legal journalists have their own Twitter feeds, and these legal journalists for their job, have to stay on top of what's going on in all of these courts throughout the nation. They've gone ahead and subscribed through the PACER portals to get notification of newsworthy cases, and a lot of times the federal appellate courts will email word of those rulings before the decisions are posted online at the website. And so it's a regular occurrence now for me to be learning about new decisions even before they're posted to a court's website as a result of folks like Zoe Tillman or Mike Scarcella of the National Law Journal tweeting about them. And oftentimes they will upload copies of the decision to one of the services that allow journalists to put up PDFs very easily. So that tends to be the way these days that I'm learning of these things. But I think that folks still find the blog useful because if you're not on Twitter right at the time that those tweets come out, I think one of the differences between Twitter and a blog is that at some point it becomes much more difficult on Twitter to see what was going on over the past week, for example, that it might be to scroll through a week's worth of entries at my blog, which I think is a little bit easier, perhaps. And so I think in that way and others that the blog still does provide a useful service to people.
Well, that's the thing about Twitter, right? Is if they say if a boat sails by on Twitter and you miss it, you don't know, right? I'm curious too. Do you read all the opinions you write about, or do you tend just to, if it's coming from someone else's work, you just tend to go with what they were? How do you read every opinion?
Well, I'm going to have to confess that the answer to that is no. But I do try to read enough of an opinion to see if there's anything interesting in it. And then, of course, to make sure that I'm accurately capturing what the decision says, which from time to time can be a challenging endeavor. And as an appellate practitioner myself, who is fortunate to represent parties that have appellate decisions written about them in resolving an appeal, I can appreciate the fact that it can be difficult for someone who's not involved in a case to necessarily appreciate all the niceties when I see articles written about cases in which I was the attorney for a party. So that does help me try to become more sensitive, to be careful. And I think that, not to speak about overarching goals, but when I started my blog as a largely unknown person on the national appellate scene, one of my goals was to try to ensure that as a result of reading what I'm writing here, that nobody would necessarily think worse of me than they had thought about me before they read it. And so that had kind of been my overarching goal in doing the blog. There were from time to time disagreements with readers. I had favored the change in the federal appellate rules that would allow people to cite to unpublished opinions. Judge Kaczynski out of the Ninth Circuit was leading the effort to oppose that rule change, and it was, I guess you could say, uncomfortable perhaps to have such a, at least as of that point, a highly thought of and highly regarded judge not agree with you in a public way.
Yeah, who was not afraid to speak publicly, or was not uncomfortable about speaking publicly compared to other federal appellate judges. And you mentioned something really important, and that was being accurate when you're reading an opinion. And I'm curious, do you have any tips on getting to the heart of what's important in an opinion and getting it right? I think of the Obamacare decision, and the major news groups got it wrong initially, and SCOTUS blog got it right because they're very good at what they do, and they recognize it's more important to be right than to be first. So what's your advice for people that haven't practiced appellate law as long as you have, and for journalists too, getting to what's important and being accurate in an opinion?
I think that with so many things at the appellate level, it tends to be, in many respects, a group effort, beginning with the judges who are themselves writing the decision. I've been fortunate over the past several years to be involved with the Appellate Judges Education Institute's AJEI conferences from year to year. And that's a continuing legal education presentation that is done by that organization together with the ABA that occurs once a year. And every year they tend to have a legal writing teacher come in and speak not only to the attorneys, but also to the judges, giving advice how to write good briefs, how to write good opinions. And I think that some judges take that to heart and try to make it very clear what the issue is that the opinion will decide, how's the issue resolved, and to put all that up front and in the back and in the middle so that it becomes very difficult not to understand how the decision came out. Other judges, for whatever reason, are not necessarily as interested in making it easy to figure out what a decision has decided. And so I think that initial responsibility rests with the judges in trying to make these decisions as clear as possible, recognizing that members of the general public, not only legal professionals, but journalists, members of the general public, will have access to the opinions. And then secondly, I think it is important for news publications to link to the decisions themselves in their articles where they're available online to allow people to be able to see for themselves what the decision says in addition to having the reporters take on it. I think that is very valuable. And then finally, and perhaps most importantly on the reporting end, just to try your best to make sure that you've given the entire decision careful attention and that you understand it. One thing that I have heard legal journalists say again and again as our time in the internet age grows is how much their job has changed from the time where a Linda Greenhouse or even an Adam Liptak early in his career could get an opinion from the U.S. Supreme Court, could sit down, read it from cover to cover, call on the phone relevant law professors and maybe even the attorneys for the parties, and get this sort of full and complete understanding of what the decision means before they had to write and turn in their article that would appear in the print edition of the next day's newspaper. Now what we see, and this is not a criticism, but because of the internet, maybe half an hour at most will go by before there are half a dozen articles about a decision.
Yeah, and you tweet about it first.
Right. And in those instances, it is much more difficult. And so like you said, with the Obamacare decision where there was a particular judge whose separate writing held the answer, or for example, to go back a number of years, the Bush v. Gore case, which was decided by a per curiam opinion of the court, where the reporter of decisions does not issue a syllabus. And so this huge opinion came out late at night that had no summary that preceded it. Those are very difficult for reporters to come to the right answer on. But like you said, that was an amazing result for SCOTUS blog to be pointing out the errors in the initial reporting on the Obamacare decision, and they got justifiable credit and attention as a result.
Well, it's funny because I remember I was driving to work on Lakeshore Drive and I had NPR on and they broke in with the story. And I remember I'm like, this doesn't make sense. I wish I could look at my phone and see what SCOTUS blog is saying because I know they would get. So we count on you lawyers who write the blogs to help us oftentimes. And you were talking about how judges write the opinions in the seminars you go to. I'm curious, are there some appellate judges you look forward to reading their opinions when they're the ones that are writing, and some you're like, are there some judges you like better than others in terms of how they write?
Well, absolutely is the short answer to that question. Yeah. And I did publish an article in the Council of Appellate Lawyers publication called Appellate Issues for the ABA. That included a list of my sort of the baker's dozen of my favorite appellate judge writers on the federal bench. And a number of excellent writers have joined the federal appellate ranks over the past years as well. So I don't know if that list would necessarily stay the same today. There would definitely be some changes in it because some of them have moved on to other positions. But yes, and one longtime favorite to whose opinions I've linked recently on my blog is Frank Easterbrook. He's someone who's been a federal appellate judge for many, many years, but he can usually be counted on to write crisp, interesting opinions that discuss the law in a way that is, to me, easily accessible, even if it's an area that I don't necessarily practice in. And oftentimes, as an advocate, if I need to explain an area of the law in a brief that's to judges who may not be familiar with it, I will try to look for an opinion either by him or by some of these other judges on my list to see if I can find something that they've written that helps to explain the point, because oftentimes their decisions contain these very useful passages that can be used to help other judges understand areas of the law that they might not be familiar with.
Interesting. I'm guessing when you started your blog, you were thinking it would be good for business development, right? In addition to you just enjoy it.
I'm not sure if business development was ever the main focus of it, as opposed to trying to develop something of a community of people interested in the subject, the same way that appellate Twitter has evolved. But yes, there have been some helpful business development opportunities that have arisen out of it, even though at the same time, I think that anybody looking to compare whether the effort put into the blog justifies the business opportunities generated from it would ultimately conclude that maybe it was not the best way to do that, as compared to that monthly appellate column that I was referring to earlier, that I think has helped establish me as an appellate authority in the geographic region where I practice, which has been invaluable.
Well, so many people, though, especially back in 2002, or maybe a little after that, but I'm sure you remember when everybody wanted to have a law blog, BLAWG. And some of those were really good, but many of them kind of weren't, right? Because it was, sometimes I think lawyers have a real disconnect on offering something that's useful to people as opposed to just self-promotion. Right? That's been a problem over, and maybe not a problem. That's why it doesn't work, I think, over and over and over. I'm curious, do you ever talk to lawyer friends who want to blog, and do you ever just have to say, listen, if you put in, well, my firm and I, no one cares. Give them something useful. Do you ever have those conversations or give advice on how to have a blog that's useful for your audience and for you?
Right. I think that you're right that to the extent somebody's blog becomes entirely self-promotional, that it tends to be useless in terms of having others be interested in it. And so I think that it can be useful in terms of demonstrating that you have a knowledge and maybe even a mastery of a particular subject matter area, and that those are the types of blogs that can be very successful. Like there's one called the Patently O blog that covers patent law decisions. And the author of that blog, you have no doubt when you read that blog that this person, who's now a law professor, he had been a practicing lawyer before then, is someone who really understands this area of the law. And similarly, I think that people who read my blog can appreciate that the appellate area is one that I focus my attention on professionally. But you're absolutely right. If you just produce a blog that's talking about, here's the types of cases that I'm handling, and here's the results that I'm getting, it won't be something that people are very interested in. And yet, nevertheless, speaking with respect to my blog in particular, it never has failed to surprise me as to who is following it. And so I remember in the early years, there was a decision handed down by the Sixth Circuit one day that involved a pro se litigant's appeal of an order from a district court that had rejected the litigant's claim that he had a constitutional right to visit his public library without wearing shoes. And so I remember wanting to blog about this as soon as I saw the opinion, and thinking to myself, just inside my own mind, there are a couple of ways I could title this post. Like, you thought you've seen the most absurd claim for a constitutional right ever, take a look at this case. But that at the same time seemed a little bit mean and cruel, perhaps. So I thought instead I'll just try to be clever and have the blog post be no shirt, no shoes, no literature. And so I put up a post under that title, and maybe 30 minutes later, the individual whose case that was is emailing me to tell me that to send me the link to his website where my readers could access the briefs that had been filed in the case. And I felt to myself, as soon as I got that email, thank goodness I had not cruelly ridiculed this case, because then the guy either would not be sending me an email, or if he was emailing me, he'd be very upset with what I had written. And so that again is another goal of mine, is to try to make it interesting, but not biting sarcasm necessarily.
And is that something you feel like you've had to become more attuned to? Because I feel like the world is just more attuned to that now than perhaps we were in 2002.
I think that's right. It's something I've tried to live by as part of that guiding principle I mentioned earlier of not making people think less of me than before they encountered the blog. But even yesterday, I linked to a decision from the Eighth Circuit where this 3-judge panel had rejected an argument that a transgender inmate should be referred to by the inmate's preferred pronouns. And the title to that post that I had, if I recall correctly, was something along the lines of, another appellate court is not interested in a litigant's preferred pronouns. Because a few months ago, the Fifth Circuit had essentially said the same thing in an opinion. It was going to use the pronouns of an inmate's, based upon the inmate's gender assigned at birth, as opposed to using the preferred pronouns of the transgender inmate at this time. And I was concerned that somebody might think that even that title was somewhat controversial by saying what it said. But fortunately, it was not received that way. And it did end up on Twitter, at least, resulting in a conversation as to whether courts should give more deference to using someone's preferred pronouns or not, which is obviously still a raging topic these days.
I'm curious, is there a circuit split on that yet?
I don't know if that turns out to be an actual issue of law that the case presents, as opposed to perhaps an issue of preferred behavior towards other people in terms of dealing with individuals. But my understanding is that at least at the Supreme Court level, and this was something somebody pointed out in one of the tweets that followed the discussion that my initial tweet caused, was to point out that in the Gavin Grimm case that was appealed to the U.S. Supreme Court, several conservative Christian organizations had attempted to file amicus briefs that used a different gender than the title of the case in front of the Supreme Court used. And the clerk of the Supreme Court, through a deputy clerk, wrote letters to those attorneys that sought to file those briefs saying that you can't change the caption of this case from what it is, which was using the individual's preferred pronouns.
I think that might be a story for us. Very interesting. That's an example of how useful your knowledge is. And on that note, that's everything I wanted to ask you, Howard. Would you like to add anything else?
Well, I just wanted to say that the ABA Journal blog, if I could call it a blog, is itself a wonderful resource. And
Thank you.
Just as you were so kind as to say how helpful my blog can be from time to time, I have a lot of admiration for the work that you and your colleagues there do on that blog day in and day out. And I wanted to just congratulate you guys on continuing to have a wonderful effort that is incredibly useful. And I do appreciate every time that someone throws in a hat tip to me. But I just wanted to say, that's a great resource and one that I look at regularly to see what's going on.
Well, thank you so much, and thank you for joining us. I really appreciate it. And listeners, thank you for joining us too. If you like what you heard today, please rate us in Apple Podcasts. We'll see you next time for another episode of the ABA Journal's Asked and Answered.